SJC-11949, Marchand v. Department of Corrections.
Mr. Galvin, good afternoon. I'm sorry, Mr. Hanson. Good afternoon.
Good afternoon. May it please the Court. Assistant Attorney General Kirk Hansen on behalf of the Department of Correction and Human Resources Division. This case presents a straightforward legal question: whether entitlement to assault pay under Section 58 is contingent upon employment or whether it can continue after an individual's employment with the Commonwealth has ended. The Appeals Court held the latter, and in doing so relied on its previous decision, Moog v. Commonwealth, as settled law. But as the Commonwealth argued in this case, Moog's analysis was based on limited arguments and limited analysis of the statute and was incorrectly decided.
Do you think, because the Moog case spends a lot of time on this, and I take it that's what the Assistant Attorney General argued, at least orally there, which was making the analogy between Chapter 41, Section 111F, and this. Do you think they're exactly the same, or you're saying, I'm not going there, it's the arguments I'm making here?
It's the arguments we're making here, Justice Botsford. I think what happened in Moog was that 41-111F, they were focusing on the purpose behind the statutes, but as the Appeals Court rightfully noted, the language is different in 41-111F, and therefore...
And you could see why somebody would say, no, this isn't the same. I mean,
Yes, but certainly with Section 58, which was passed in 1955, it's a very different structure, and specifically Moog only looked at the Appeals Court in Moog looked at a very limited portion of the language there, not even all of the language in paragraph 4. And as this court and courts have recognized repeatedly, in interpreting a statute, you have to read the entire statute, give meaning to all of the words that are there. Looking first at paragraph 4, I would note that it starts by saying, notwithstanding the provisions of this section, and then notes that an employee who suffers an injury that results from an act of violence of a patient or prisoner in their custody and entitled to workers' compensation benefits under Chapter 152, then gets this additional assault pay benefit, quote, without such absence being charged against available sick leave credits, even if such absence may be for less than 8 calendar days duration. This language about absence, giving that its plain meaning, absence has a natural sense of presuming an eventual return. It implies that this is for current employees who are absent from the job due to an injury or disability, but will eventually return. It does not indicate that this payment is intended to go beyond employment, whether that's because of resignation, retirement, or termination.
how do you, if I understand the factual setting here, there is, the injury happens, he's on temporary disability for a while?
He begins on Section 34, which is like the total disability. It then became Section 35, which is the partial disability, where there's an earning capacity and the workers' compensation benefits are reduced.
And was it in 11 that when was the disability retirement?
I believe the disability retirement, Your Honor, was allowed in 2013, but he applied for it in 2011, and so the benefits would have gone back to, I believe, the date of the application.
So this is just a side question, but can a person be getting disability retirement benefits and workers' comp at the same time?
Yes. And this specifically, this is addressed in the policy section of the policy arguments in our brief, but it's Chapter 32, Section 14 recognizes that it's possible for a person to get workers' compensation benefits and accidental disability retirement benefits for the same injury. And because the legislature has a long presumption of not wanting to allow double recovery from the Commonwealth for the same injury, there's an offset provision. And the way it works is if the workers' compensation benefit is greater than the pension portion of the of the disability retirement benefit, there's no pension paid. If the pension portion is greater, then as long as workers' compensation is being paid, only that delta, the difference, is paid as a pension.
And so the retirement what's the other one called besides pension?
Superannuation, the annuity.
The annuity gets paid anyway.
Correct, because that's based off of the accumulated deductions that it's paid.
Okay, the annuity gets paid anyway, but I
The
get it.
pension portion is what gets reduced.
So how would somebody get more by not working than the person who gutted it out and said, I know I'm hurt, but I'll still come to work each day?
Well, what would happen, Chief Justice Gantz, is, I said, there's the offset provision for workers' compensation against accidental disability, but there is no offset provision for assault pay in Chapter 30, in Chapter 32, or anywhere. And so because the way Section 58 is written, the assault pay is whatever the difference is between the workers' compensation benefit and the regular salary. That would then be added on. So, for example, if someone was out on total disability, you can presume that the workers' compensation would be 60% of their salary. The assault pay would be 40%, the remaining 40% of their salary. Given the way that accidental disability retirement is calculated, the pension almost always is 72% of the salary. So you would have 60% of salary paid as workers' compensation, 12% paid as pension, an additional 40% on top to a total of 112% of the salary, tax-free, if all three of them were being paid.
All tax-free or just?
All of it is tax-free.
So, and if that same person says, I can play hurt, I'm still gonna come to work, what's the difference? The person then is being taxed on the workers' comp share or basically being
No,
taxed on the entirety of what he
If they
gets
come back to,
paid?
well, if they come back to work, somebody who's out on partial disability and therefore has an earning capacity presumably could go get a different job while still waiting to get fully recovered to come back to their main job as a corrections officer or whichever. That money being paid from the other employer as employment would be taxed as regular salary, but they would still, under this court's decision in Deleuze, still receive the full assault pay difference between whatever the Section 35 benefits are under workers' compensation, and all of that would still be tax-free.
As long as they still were employed.
We're still employed with the Commonwealth, correct?
So the tax-free is either way, whether you're working or not?
Well, the tax-free is, that is how workers' compensation benefits are treated. That is how accidental disability retirement benefits are treated. It's how assault
It's
pay
just that
is
you're
treated.
not working for the Commonwealth.
Okay,
Correct.
okay, so the difference is that it's not that one is taxed and one is not. The difference is that you would get the accidental disability above and beyond
Correct.
the assault pay.
Yes,
So
if they were
better
all
off, you'd be better off to not gut it out and come to work. You'd be better off to say, I'm too hurt to work.
Right. And again, going back, Section 58, if you read it in its whole, what it is showing is establishing rules for how Commonwealth employees are supposed to be able to use their accumulated sick leave to maintain a paid leave of absence, and how that would work if they were also receiving workers' compensation benefits. Paragraph 4 is an exception to those general rules, and exceptions are construed narrowly not to go beyond the scope of the general provisions. The main purpose, as we say in our brief, of Section 58 is to allow for paid leaves of absence through the use of accumulated sick leave. The reasonable interpretation of paragraph 4, the assault pay, is to allow for paid leaves of absence without the use of accumulated sick leaves.
Could you be eligible for assault pay, but not eligible for accidental disability if you were to leave work for that reason?
Certainly, the case law is very clear that because of how generous a benefit accidental disability retirement is, that is a heightened standard for being qualified for accidental disability retirement. So you could get workers' compensation for an injury and not get accidental disability. You may then still qualify for regular disability under Section 6 or there may be other provisions under Section 9. But yes, it's possible you could be out not on accidental disability, but still have gotten qualified for assault pay and for workers' compensation.
So somebody could basically be on assault pay and then say, I'm too hurt to work, and then turn out not to be eligible for accidental disability.
Correct, but again, we're talking about somebody who, if it was at the end, was unable to continue working. I mean, I would point back to the facts of what happened with Mr. Marchand. It wasn't as though he was terminated as soon as he started collecting accidental disability. He had 2 years and 10 months to try to achieve fitness. It was only after an independent medical examiner determined that he had reached an end stage and would never be able to come back and work as a corrections officer that he was ultimately terminated through the civil service process. So we certainly recognize these are dangerous jobs, but we believe that what the legislature was intending to do here was simply to preserve the sick leave credits of current employees. Also just noting how this statute works with relation to other statutes, 1954 was when the legislature amended Chapter 7, Section 28 to say that the personnel administrator should create rules governing the use of vacation leave, sick leave, or other leave with pay, but those rules regulating sick leave had to have an exception about if you got injured by an act of violence of a patient or prisoner in your custody, that you would then get assault pay without use of any sick leave, indicating that the legislature intended for assault pay to be an exception to the use of sick leave. 1 year later, they then codified within Chapter 30, Section 58, a chapter generally talking about how employees and agencies' relationships work. They codified how the sick leave use with workers' compensation worked, but it still goes back to this idea it's all about a paid leave of absence. And here, a paid leave of absence while still a current employee, but without using accumulated sick leave.
All right, thank you.
Thank you.
Now, Mr. Galvin, good afternoon.
Thank you, Your Honor. Your Honorable Chief Justice, members of the court, my name is Gregory Galvin, and I represent Mark Marchand. This is a situation where the legislature, in enacting Chapter 30, Section 58, was clarifying what is actually in Chapter 152, Section 69. Section 69 of Chapter 152 covers public employees, Commonwealth employees, city, town, county employees. And within Section 69, there is a provision that says if an injured Commonwealth employee, I'll use the Commonwealth because Mr. Marchand was a Commonwealth employee, if the injured
His clock hasn't started. Okay, sorry.
If the injured Commonwealth employee has accumulated sick time, they can use the sick time. It doesn't actually use the word that they have to have the sick time. It just says that a Commonwealth employee may use sick time to augment the workers' compensation benefit so that they can make up to 100% of their salary. As my brother indicated, workers' compensation benefits are not taxed. The current statute says under temporary total disability, Section 34, you get 60% of your average wage, the wage that is for the 1 year period prior to the date of your injury. Average that out, you get 60% of that. The statute says to the public employees, if you can add sick time to that, and that's taxable, the sick time portion is taxable, and make up to what your regular salary was to the extent you have sick time. Section 58 of Chapter 30 is somewhat of a clarification because the first 3 paragraphs of Section 58 indicate that when you initially go out, because the statute says for the first 5 days you don't get workers' compensation unless you've been out for more than 21 days, when you initially go out, you can start collecting your sick time. You're claiming it's a workers' comp injury. You should be getting workers' comp benefits, but because of the process of getting the claim filed, getting the information together that the person is actually off the job, there's a delay, and the legislature saw fit to cover that employee during the delay. And it said that once workers' comp starts, the compensation is actually returned back to, in the Commonwealth situation, the State Treasurer's Department to put the sick time back on the books. Now, as I indicated, workers' comp is only 60% of your average salary, so the statute says proportionately. So if you were out and it took 10 working days to get onto workers' comp, you're not going to get 10 working days credit back on your sick time because the workers' comp is only 60%. So it says in the statute, proportionately. Now you come to the fourth paragraph, and this is where my brother and I disagree, and what brings us before this court. The fourth paragraph is a further clarification. Fourth paragraph says, for those employees who are in an extremely hazardous situation, they're taking care of prisoners, they're in their care, custody, and control, so it's only the employees who have care, custody, and control of prisoners. So if the governor went down to the prison and was walking through the prison and got assaulted by an inmate, he's not covered under this particular section because the inmates are not in his care, custody, and control. It says that if you're in a situation where you're injured, as Mr. Marchand was trying to protect another correction officer who was in a struggle with an inmate and suffered serious injuries, you get the assault pay. Now, the fourth paragraph doesn't say you have to have accumulated sick time. There is no provision in the fourth paragraph that the injured correction officer has to have accumulated sick time. He still gets the assault pay.
Right.
So there's a difference in the fourth paragraph from the other three. The other three says you must have accumulated sick time. There's no provision in the fourth paragraph. It says if you're entitled to workers' compensation benefits, you get the difference between your workers' comp benefit and what your regular salary would have been, which it would be the salary at the time of the injury, not necessarily your average weekly wage. Because if you got a raise, say a month before the injury, that raise is only reflected for that 1 month in the average weekly wage. But you get the difference between the workers' comp and the salary that you were earning at the time you got hurt. Now, this court in Duluth, as my brother has indicated, found that the legislature didn't differentiate on total disability or partial disability. The legislature said you get the difference between the workers' compensation benefit and the salary you were earning. The legislature is presumed to know that there is a partial provision in the workers' compensation law under Section 35A that says if somebody has an earning capacity, whether they can actually find a job is not under the purview of the Workers' Compensation Board. The Industrial Accident Board doesn't look to see, is there that job available to the individual? What the administrative judges at the Industrial Accident Board do, they look at what the person's education. Mr. Marchand was a college-educated individual, whether or not they have some skills beyond the skill that was needed for the job they were doing. He has some computer skills, they found that, and what is your injury? His injury was a very severe leg injury. That leg injury was what was preventing him from doing the job of a correction officer, which is a very strenuous job, and that was why it was found at the Industrial Accident Board that he had a partial disability and modified his benefits from temporary total to temporary partial. That increased his assault pay benefit. Now, as the Duluth court said...
I'm afraid your time is up, so why don't
Oh,
you say in a sentence or two?
Thank you. Just, the Duluth court made its decision 15 years ago. The legislature has had 15 years to change the law. The legislature hasn't done that. Thank you.
Thank you.
Thank you.